Welcome to another episode of Divorce Explained with myself, Leanne Townsend, and my colleague, Steve Benmor, a divorce strategist and family mediator, and we're both with Benmor Family Law Group. Today, we have a rather different topic to some of the topics we've talked about before, and we're taking a more scientific approach to divorce proceedings today with this topic, and that is, why is evidence important in divorce proceedings? And those of you who are listening might think, well, evidence, we all know what evidence is. We watch movies about courtroom dramas and things like that. We know what evidence is. But a lot of people actually don't really know what evidence is in a courtroom and how it's used within the legal system. And so in our episode today, we're going to peel back the layers of what actually is evidence versus, for example, an allegation. And it's really important to understand the difference. So, Steve, I'm going to turn it over to you just with that point alone. What is the difference between something that is an allegation and something that is actually evidence?
You know, most people know that lawyers don't just do family law. There's lawyers that practice criminal law or personal injury law or employment law. And if you think about those other areas of law and the role of evidence there, you know, when somebody commits a crime, there are eyewitnesses, there's the victim, there's the victim's family that might have been there and observed it. If it's employment law, there's a manager, there's co-workers, there's people that have observed whether the employee did something wrong and why they were terminated. If it's personal injury law, there might have been a car accident, there may have been other cars and people were there and watched it. But in family law, most of the problems occurred behind closed doors. And the only people that were there when the problems arose are often the husband and the wife, who are now the opponents in the litigation. And so we face a tremendous problem with the he says, she says world of evidence, because she might say he was abusive. He might say she was an exaggerator and a catastrophizer. She might say he earned cash income. He might say, I don't know what you're talking about. All my income was deposited into the bank account. And so we have a real dilemma when it comes to evidence. And oftentimes clients will hire us and will say, everybody knew. Well, that's not evidence. Some people will hire us and say, well, you know, it just is. And you're the lawyer, figure it out. Well, no, we need this thing called evidence. So what is evidence in family law? Evidence in family law starts, but doesn't end, with our client's oral testimony. But that's just the beginning. In order to establish that what they say is true, now we begin the process of collecting circumstantial evidence. So let's use a perfect example. If there's a history of abuse, and this went on for years, did the victim report this to the police, to a social worker, to a therapist, to a children's aid society, to a colleague? If there was physical abuse, are there photographs or videos? And if it's a financial issue, so for example, he says that she earns cash income. And she says, no, that's not true. Whatever I earn, it goes into the bank account. And so is there going to be any evidence that payments on credit cards or for the purchases of large products like cars or expensive items of clothing or furniture were not in any way documented in a credit card statement or a bank statement? In other words, how did that $30,000 car get purchased 3 years ago? And she says that she bought it. The bill of sale says paid in full. There's no withdrawal. So maybe there is some circumstantial evidence to support the notion that there was cash in the home. And of course, there's the budget. In family law, both sides have to swear to a budget. And oftentimes the budget will be matched up against the income that was reported in that same year in tax returns. And if there's this mammoth disparity between the budget and the income that was reported to CRA, maybe that supports the allegation or the claim of cash income. And now we are really trying to switch allegation into evidence. And the more we are able to convert allegation into evidence, the stronger the claim is, the stronger the case is, the higher the likelihood is that we will settle this case without a motion or a trial. But the role of the spouse in conjunction with the lawyer and the rest of the team, their job is to build a case. And when you build a case, you're not building a case of allegations, you're building a case of evidence.
And a central principle of the rules of evidence is, in order for evidence to be admissible, it must be relevant to a matter that's in the proceeding, to an issue that is in the proceeding, or it must be relevant to either proving it or disproving it. So sometimes, when you're dealing with a couple who have a long marriage with all kinds of awful things that went on, some of it may be relevant to the divorce proceedings, and some of it may not be. And I give it as an example, the issue of a spouse having an affair. In a lot of cases, if you're just dealing, for example, with property issues, say that's the only issue really in the divorce, the fact that one of the spouses had an affair on the other spouse isn't really probably going to be relevant to the legal issues that your lawyer is going to be needing to prove with respect to property and equalization of property. So a judge isn't going to appreciate you trying to go down a whole rabbit hole about all the affairs your spouse had and all of that, because the judge is going to say, like, how is this relevant? Why should this be admissible? So it's really important that, for evidence to be admitted, it has to be relevant. And it's also important that evidence is reliable. And that can come up a lot. People in 2025, couples, they're often recording each other. And so, texts and recordings on cell phones and just old texts and emails and things like that, videos, they're much more common today in the family law context than they were many years ago when cell phones weren't a thing. And one of the central issues surrounding some of that evidence is the reliability of it, because sometimes text messages and videos and things like that, they can be altered. And so if you're wanting to rely on evidence like that, you're going to have to be able to show that that the evidence itself is reliable. And it's not taken out of context and things like that. And so that's another important consideration when you're looking at, whether evidence is whether it should be admissible and whether it's going to help actually prove your case and be accepted.
And like I said before, a lot of the stories that we are told are the client's firsthand experience, which we cannot discount or dismiss. But we also recognize when the client tells us this, that there's a very high probability that the ex-spouse will dispute it. And so we know whatever our client is telling us, there's a high probability that the other side is going to dispute it. And they're probably not just going to say it's just not true. They're going to look for and lead evidence, again, evidence, to disprove the allegation. So knowing this in advance causes us to say, okay, that's great. Mark it all down, write it all down. Now begin collecting the evidence. And for those that have been following Benmor Family Law Group, we know this all too well. And so if you go to our website, benmor.com, and you click library, there are 2 documents that we have produced to help people build their library of evidence. One document is BFLG's 10-step checklist for divorce. And the other document is BFLG's financial disclosure checklist. If you go to those 2 documents, you will see line by line the kind of evidence that will be helpful. Now, that's called documentary evidence. But then there's other evidence. There's other witnesses, people that might have observed what you want to prove, or people that know firsthand, or records kept by third parties, maybe banks, maybe employers, maybe Children's Aid Society, maybe police, maybe therapists. So there are documents sitting in other institutions and agencies. On top of that, there might be text messages and emails. There might be video. There might be WhatsApp communications. And all of this is considered evidence. And think of a puzzle. You don't just finish a puzzle with one piece. You put together piece after piece after piece. And at some point in time, you might not have all the pieces, but if you're looking at that puzzle, now you sort of see the full picture, even though some of the pieces are missing. And so that is, in effect, the role of the spouse, the lawyer, and the rest of the team in building the full puzzle, including evidence.
And while it's really important for clients to understand what actually constitutes evidence, it's equally important for them to understand what is not evidence. And a good example of what is not evidence is something that happens a lot is, lawyers are good at writing letters to the other side, where in the letter, they put all sorts of what I would call allegations about your client that your client might get very upset about because they're in this letter. And while a letter a letter from a lawyer can potentially become evidence, the statements or the allegations that are in this letter are not going to be seen as being evidence. They're not evidence of their truth. So they're hearsay, essentially. And by that, what I mean is that just because a lawyer writes something about you in a letter, it doesn't make it true. Just like if your spouse's mother, your mother-in-law, was saying something to your father-in-law about you that you dispute the truth of, that doesn't make it true. And so something written in a letter that's an allegation is not evidence of the truth of what it's alleging. It's just a letter. And similarly, out of court, we have something called hearsay, which is an out-of-court statement that someone tries to introduce into evidence for its truth. And so that an example of that would be that your mother-in-law says that, that Sally, my daughter-in-law, she is just a horrible mother. She is abusive to my grandchild, and she's just horrible. And mother-in-law says that to father-in-law. And your spouse, Sally's spouse, tries to introduce mother-in-law's statement as evidence. That would be considered hearsay. Mother-in-law would have to be there to testify in person
as to her own observations. Exactly. And not as to what someone told her.
Exactly. And so what Sally told Susie, who told, Sandra, who told Stephen, doesn't matter. Those people have to be prepared to come to court and under oath testify about what they personally observed and what their own specific experiences were, not what they heard about from someone else.
And another topic that comes up in the subtopic of what you just said, Leanne, was what did the children say? And it's very common in family law for each parent to come to court and say, Junior said such and such. Well, technically, that's hearsay too. Now, this is where things get a little dicey because under Rule 14 of the family law rules, the court on a motion has the right to consider hearsay evidence, but on a trial does not. For those of you that are non-lawyers, this now gets a little complicated because the idea behind it is family law rules were built not just for domestic cases between parents, but also for cases involving the Children's Aid Society. And they want to be able to lead evidence as to what the children told them. And so they relaxed the rule there. But the bottom line is that even when the children have important information to share, there are mechanisms to get that information in. And in Ontario, we have this concept, this product called a Voice of the Child report. Separate from that, we also have legal representation for children offered by the Office of the Children's Lawyer provincially, or private practitioners do it as well. And thirdly, there are parenting assessments whereby psychologists and social workers would be involved to interview the children as well as everybody else and write a full report, which is a mechanism, all three of them, is a mechanism to get the views and preferences, or more importantly, the evidence of the children involved in the court decision-making process. And so evidence is so important. And one of the first things I say when someone hires us is your job right now is to now begin collecting the evidence of what it is you would like some stranger, whether that stranger is an assessor, a mediator, the other lawyer, or a judge, to determine. And it's not going to be enough for me to take whatever you've experienced, put it in a letter, and say, this is the truth, believe me for it. No, we need evidence. And so this topic called evidence in separation and divorce is, like Leanne said, it's the science behind a successful divorce settlement, because there's very little science. It's mostly art and finesse. But when it comes to the science of separation and divorce, and there's a lot of water under the bridge, there's a lot of history, there's a lot of considerations, whether it's parenting or financial, evidence is the key to a successful divorce settlement. And any spouse that's done a very good job building their evidentiary record is a spouse that will find a much shorter distance from problem to solution, therefore reducing their overall budget and improving the likelihood of an early and proper settlement. I hope this topic has been helpful. I hope it's been educational. And I thank Leanne and those viewers who tuned in to hear on the subject of evidence in separation and divorce. Be well.
Thanks, everyone.